Real quickly before we begin, I want to thank this video's sponsor, CarMarshal.com. CarMarshal.com can save you lots of money on buying used or new vehicles, cars, trucks, school buses. If you want to save money, I'll have a link in the description down below. I know I'm going to...
Thank you for letting us be here today. I guess if you want me to, if you want to ask me some questions, that's fine, or I'll just kind of go through in order of his discussion.
Are you making a public records request under the Miami-Dade County Home Rule Charter?
No, sir. I made the request under 119,
okay.
And then I later found that the Home Rule Charter also has the same requirements, so I guess I'm naming it under the Florida Constitution 119 and the Home Rule Charter. If the Home Rule Charter can't be applied, I have no problem canceling that out. That's no big issue for me. His first point, it actually is not very accurate. He's saying that all my records requests are to the city. I've filed records requests to the city for records of the city, and I've filed records requests to WSH and Zeskine for their records specifically. Under the law, it's very clear that he is an agency. They're acting as city attorney. They have taken over a public function to the exclusion of the city, and public records law follows because of that. Whether it's in individual or official capacity, to me, Your Honor, I'm a pro se. It was a little bit confusing. I kind of probably think his argument towards individual capacity being stricken is correct. Whether it's individual or official capacity matters not to me. What I care is who the injunction names. And as they noted in the Florida Rule of Civil Procedure 1.610C, the rules for injunctions, it says that every injunction shall be binding on the parties to the action. There are parties to the action, and while I understand the argument about naming individuals in their official capacity is redundant and equivalent to naming the municipality, my understanding is that's for damages, to make sure you don't double damages. I want to make sure that they're named on injunctions, and if any of the individuals leave and go seek employment elsewhere, I'm afraid that they could continue to commit these abuses and not be enjoined. So that's why I want the law firm, the city, and the employees individually named. I would have never named the city except for some of the what I am alleging to be violations were done through the city, and I don't know what individual is responsible. For ones where I know the individual that's responsible, I have named the individuals.
What about the advice issue?
I was going to get to that. On the advice issue, it's really not about advice. I understand if somebody hurts me or some person talks to their attorney gives them bad advice, and that leads to me being damaged. My claim is against the person who did damage to me. That person, is up to them if they want to sue for malpractice their attorney. That's not the issue here. The issue here is records requests were directly sent to Zeskine, and he refused to act on them. And as well, I believe that their actions, or the totality of their actions, are criminal, Your Honor. In Florida Statute 838.
Okay, let me stop you there. If it's criminal, Catherine Fernandez-Rundle is the one that you need to talk to about that. That has no applicability, and there's a case, I don't have it off the top of my head, that says the standard in a criminal case has no application in the civil public records request law.
I understand, Your Honor. I'm not trying to bring criminality in. I'm just saying the statute itself says that they can't conceal records or let other people, or cause other people to conceal records. I plan to eventually file complaints criminally, and I wasn't trying to bring that up in there. I wanted to explain as to why, because I don't agree that they're named because of giving their clients bad advice. The next thing, we were talking about breaking up the counts. I understand that counts are supposed to be split up. I disagree with their argument that I commingle the counts. Each count is for a pattern in practice. To get an injunction, you have to show a pattern in practice. You have to show multiple violations. So if each of my counts is for an injunction and for a pattern in practice, it has to show several violations. If you'd like me to split it all up and say 1, 2, 3, but I don't know how I do the pattern in practice count, I can split it up. If Your Honor, if you prefer that, I have no problem doing that. I think that just increases the work and obfuscates the issue, since we're going for pattern and practice counts for the injunction. Next, I'd like to talk about the home rule for untruthfulness and the Zeskine and the litigation privilege. I absolutely understand litigation privilege bars any torts that come about from actions that happen inside of litigation. There is one case I provided a copy inside the documents I gave you. It's Deberkamp v. Fisher. And I'll pull this just so I kind of approach the bench real quick. I can show you which one it is.
Okay.
It's the fourth document in front of. Here, I'll try to have this one, make it as nice for you as possible. It's the second one right here. In the very beginning, it should be the third or fourth document stapled. I'll show you.
It's Debrin Cat, DEBRINCHE versus Fisher. Thanks.
And Opposing counsel has a copy of this. I agree this is somewhat weak, Your Honor, and I might be misreading the law. I've highlighted a few things on the front. The issue is there was a case, Wolf v. Foreman, out of the 3rd District. In that case, it extended the litigation privilege to include the filing of a complaint. And by doing such, it basically barred any malicious prosecution or abusive process claims. Deberkamp v. Fisher overturned it. And in this case, it wasn't just that it was a malicious prosecution for filing a claim. The person who filed for malicious prosecution got added as a party in an amendment, which happened during the course of the proceedings. So I understand the litigation privilege, and I understand when it applies as an absolute bar. But it's not as absolute and far extending, which I think Deberkamp shows. And if you look in the first column down at the bottom, it says torts, which I've highlighted. You know, it talks about litigation privilege. My understanding, unless I'm incorrect, is torts have to deal with money damages. Like if they didn't provide me records and because of that I lost a lawsuit, or they didn't provide me records and because of that I couldn't file.
What relief are you seeking for untruthfulness?
Just a declaration or a writ of mandamus or an injunction. Just stop them from continuing to defame me. And I understand I have defamation cases that's separate from that.
You can sue for defamation.
However, a public official acting in performance of their official duties has absolute immunity from defamation. So my only recourse, my only legal remedy is to go after the untruthfulness, Your Honor.
I'm not sure that's the case, but anyway.
There is a case, Bailey v. Wheeler, it was from 2016 from the 11th Circuit Court of Appeals, where they upheld a lower court not dismissing a defamation case that was combined with a First Amendment retaliation, where it was done by police officers. I'm not sure if that applies. It was from Georgia, and I know it's 11th Circuit, but being it was dealing with Georgia defamation, not Florida defamation, I'm not sure if it applies. But typically, any public official acting in the performance of their official duties has absolute immunity from defamation. That's been the standard in Florida for quite some time, to my understanding. And so, to that respect, I have doubt over whether the untruthfulness claims against Zeskind are or are not barred by litigation. And that doubt, I think, allows or justifies a declaration that either the litigation privilege covers it or the litigation privilege doesn't cover it. If it covers it, I have no problem withdrawing that, Your Honor. The ones against the other named defendants, Chief Roll, the manager, and the clerk, I have on video, and those are straight lies they made, which are not covered by litigation privilege. So if we dismiss the untruthfulness against Zeskind, I understand, but I think that without a doubt, I believe the untruthfulness against the other individual defendants should stand, Your Honor. Also into the untruthfulness, they cited a lot of cases. Herbert's was the only case that they cited that was actually would be binding, but Herbert's is differentiated. The untruthfulness says that they can't furnish false information. It also says they can't omit significant information when providing information to the public. Herbert's was dealing with omitting significant information, not with providing direct false information. Their other cases that they cited from the Ethics Commission were mainly based on opinions, and I absolutely agree. An opinion is not truthful or untruthful, it's an opinion. In my case, the defendants made direct statements of fact they knew to be untrue when they made them. And they're statements of fact, not statements of opinion. So I think that should differentiate us pretty good there. I'll go to their, we talked about damages. I'm not asking for damages, Your Honor. They noted that I'm not entitled to costs. I know I'm not entitled to fees because I'm pro se, but if I'm successful in this, I absolutely am entitled to costs, which haven't been addressed, and so those issues are not moot.
Do you have a case that says that a pro se person is entitled to...
No costs, not fees. Just my filing fee, my court reporter, I don't get paid for my time, but I get paid for the money I have to put out if I'm successful. The refund, for one instance, I had given Chief Roll records. I later filed a records request asking for the documents I gave Chief Roll. The city provided me with an invoice. I had to pay that invoice before I can go see the records. I pay the invoice, I go pick up the records. Not a single record I had given Chief Roll was in there, and they had given me other documents, which they had already earlier provided me. So I informed them that they had not given me what I had requested, and they then falsely claimed, Chief Roll did, that I had given them no documents. If I asked if they're not going to give me the documents I requested, if they would refund my money. They're refusing to refund my money. I know he cited the voluntary payment doctrine, but the voluntary payment doctrine requires that I have knowledge. I couldn't have known that he wasn't giving me the documents I was asking for until after I paid for them. It would be, Your Honor, it would be like me calling up a car dealership and ordering a Corvette and putting $70,000 on my credit card, having them delivered, and they deliver a Hyundai. You know, that's not what I paid for. There was no way I could have known until I paid for it. They're refusing to refund me. And if that's considered a damage, which I disagree with, but I could be wrong, I'm pro se, then I'm happy to drop that, and I'll just view that as them willfully committing fraud and not paying me back. And I'll deal with that in my federal civil rights suit, and that'll be another RICO count for wiretap, or wire fraud, Your Honor. In terms of the re-litigation, this is what I really want to start off with. Things that go in the order I expected, but that's okay. Your Honor, the reason we're here, for years now, the city and WSH has been refusing to follow the law. I've sent them emails, I've sent them the law, I've sent them case law, I've sent them statute, I've given them explanations, I've talked about it in city council meetings. They refuse to follow the law. That led to the filing of the last lawsuit. During the course of the last lawsuit, they continued to violate the law, which made me file this lawsuit. I also included in this folder that I gave you are at least 3 other violations that they've made of public records since I've amended the lawsuit, Your Honor. They absolutely refuse to comply with the law, and that's why I wanted an injunction. I want them to follow the law. In terms of being relitigated, I'm not relitigating the old case. The old case dealt with Request A. In this case, we have Request 2. Request A was sent to the city. Request 2 was sent to Sam Zeskine. Request 2 was similar to Request A, but it had different language and was sent to a different person. And in Request A and Request 2, they claimed exemptions for attorney work product, exemptions for risk management, and exemptions for insurance claims files. All those exemptions require there to be tort liability or possibility for tort liability against the city. And in the document I gave you, it explains that very well and goes into detail about that. The issue there is the Request A and Request 2, I requested documents related to the city's decision to defend Merguido in my defamation case. And so when we filed the defamation from Merguido occurred April 2013. Florida Statute 768.28 has a 3-year statute of limitations, which would have closed out in April 2016. Request A was filed in May 2015 within the statute of limitation period. Request 2 was filed June 2016 outside the statute of limitations period. And since the applicable statute of limitations period has ran, there's no liability the city could ever possibly claim for the defamation case. The exemption is no longer valid, and they should provide that. However, instead of providing that, they tried to only provide me a few records and then tried to excessively charge me for reviewing the records, the small portion of the records they're going to give me. I'd also like to note that in the last trial, they said there were only 5 responsive documents, and they brought this up here. However, in the first hearing in this case, Mr. Zeskine admitted there were 500 documents, and they eventually gave me 120. I'm not sure if you saw 380 documents during your in-camera inspection. I was not there, so I couldn't speak to that point. If we could go into a couple of the violations that have occurred since then, because I would like to get these documents, and maybe we could clear this up. If you open up the document, the very first document, you see an invoice. And this is an invoice that was sent to WSH. And you can see what I've highlighted, what they're redacted. They're claiming that these redactions are attorney work product. So they're claiming the item number, the email of the person. How can any of that that's redacted on this page be attorney work product? To be attorney work product, it would have to reflect either a mental impression, a legal theory, or a litigation strategy. I don't know how an item number or an email would encompass that, Your Honor. So that's another one that's been violated. I asked actually Mandel if he would provide me, and he is the one who's refused to provide me and claimed the work product exemption on that. If I can just get 30 more seconds, if you go to the very next stapled document, it starts off True Homestead Media Public Records Request. In this one, I filed a records request on February 3rd of this year. By February 8th, the clerk had all responsive documents. Then later on February the 8th, she sent the responsive documents to Mr. Zeskind. Then they provided me with the responsive documents on 3/8, 30 days later. The responsive documents consisted of about 30 emails. It's completely unreasonable to take 30 days to provide those. And the emails that got sent out, the clerk asked if anybody spent more than 30 minutes to let her know because they were going to charge me. There was no bill from the client or from the attorney, so obviously he spent less than 30 minutes to go through those emails, but then still spent 30 days to provide them. The law is very clear. The only allowable delay is the time it takes to retrieve the records and review them for redaction. I would understand if it takes 4 or 5 days because they have other things going. I'm not calling that unreasonable. But 30 days after all 30 emails are produced, that's completely unreasonable, Your Honor. The rest of it I'll save. I don't want to take up any more of your time.
I appreciate it. All right. I mean, you all reserved 30 minutes total.
I understand, Your Honor. We were discussing that earlier.
10 seconds, Your Honor, just real quick. He was talking, we're here on a motion to dismiss, just talking stuff up, really up in the
I
play.
agree.
And then also, before Your Honor makes any ruling on relating to Weiss Sirota and Mr. Zeskind and Mr. Stetten, if we could just maybe give us a week to address this case and maybe submit some supplemental memo to Your Honor on it.
Well, for now, I think Dr. McDonough has correctly conceded individual capacity. He doesn't need an individual capacity claim. So to the extent you still want an opportunity to argue that the private, actually any of the individual human being defendants or private defendants like Weiss Sirota shouldn't be defendants at all, I'll give you an opportunity. But my view for now is that the individual, to the extent they are individual capacity claims, are going to be dismissed by agreement or withdrawn. Okay, and an order should reflect that. To the extent, and again, I think he correctly conceded, to the extent there are public records requests made under the Miami-Dade County Home Rule Charter, I think those should be dismissed. Although it's not clear to me that the counts are specifically seeking relief. The counts appear to be limited to 119.
Yes.
Okay. I am gonna, it's your requests. There are several, 9 or 11 or however many it is, and so I do want you to, rather than incorporating all the paragraphs, I do want you to say,
Request 1, request 3, request 5, or whichever
the
one's
request I
relevant.
served on, I submitted to Stetten, this is the request I'm seeking relief for. The request I submitted to Zeskind, this is the request that I'm seeking relief under, and this is the date I submitted the request. It matters because of this amendment to the statute that happened in 2017 that says it's only applicable to public records requests served in or submitted in 2017, and it makes a difference. So I am going to ask you to, I'm going to dismiss without prejudice and ask you to replete it and do it specific, so there's no ambiguity about whether you're seeking relief under request A. I'm not inviting more comment. This is my ruling. So whether you're seeking relief under request A or not. With respect to the untruthfulness claims, I believe those also should be dismissed.
If I could just to clarify.
As to the private defendants, as to what I'll call Weiss Sirota and its attorneys, that the untruthfulness claims should be dismissed based on the litigation privilege. I'm not dismissing them as to the municipal employees.
Okay. Just so I make sure I understand what you're saying, Your Honor. So when I have, let's say, count 1 against Stetten.
How you choose, I understand your point with respect to your request for injunctive relief, which of course I'm not ruling on the merits of it now.
I understand
your point under Daniels versus Bryson, which is the case that talks about that. Okay?
Well, my question is, like, count 1 against Stetten for where I'm trying to get injunctive relief. Do you want me to, in that count, say each one, list each of the records, read you the request that I can test in?
You submitted to Stetten that you're saying he failed to comply.
Yeah, that's what I'm saying, but it would just be one count for Stetton, and each one that he violated. I wouldn't break that up into 3 for Stetton. That's what I'm asking.
Oh, no.
You know what I mean? So I'll end up with 85 counts, and I don't want to do that, Your Honor. I don't see how that helps anybody.
No, I think it should just be clear as to each defendant which specific.
I can clarify that.
Separate count for each defendant?
Which is what I already have, but I'll just clarify
but
that.
if he's saying now that there were 3 records requests submitted to Stetton, I don't need to have one count for Stetton for one records request, another count for Stetton for another records request, another count. I think it should just be clear as to each defendant.
It'll be
request
Stetton
and the
requests
date.
1, 3, and 5. Zeskine requests 2, 4, and 6.
Correct.
No, I understand, Your Honor. I can do that. That's no problem.
Okay. All right, thank you.
Thank you so much,
So
Your
you
Honor.
can just say, write up an order that says it's granted in part as set forth in the transcript of proceedings dated May 21st, 2018. Okay?
So for the reasons stated on the record?
Correct.
Thank you,
just
Your Honor.
write it up. Thank you.
Thank you so much, Your Honor.
Thank you.
That one?
You want that?
Can I really have it?
Make sure I didn't make any notes. I don't think I made any notes. So you're gonna get your workout today.
You're absolutely fine.
Dr. McDonough, if you want to take this back, you may want to reuse it, what you gave me.
Thank you, Judge.
Thank you,
Okay.
Earl. Thank you.
Thank you, Your Honor.
And I think this was your response. They included your response in their
Yeah,
findings,
I saw that.
which, by the way, I appreciate very much. Makes my life easier. I just sit there and read motion, response, reply.
I didn't think about that, but I spent a lot of time tabbing and color coding it for you, Your Honor.
I appreciate that. I have a lot to read.
Thank you, Judge. We'll see
Thank you.
What city's the other case that you're dealing with?
It's Miami Dade College.
Okay.
I'll start the trial tomorrow.
Dunna versus Stetton and others. Counsel, please state their appearances for the record beginning with the plaintiff.
Dr. James Eric McDonough, pro se plaintiff.
Good morning, Your Honor. Matthew Mandel and my partner Sam Zeskine on behalf of the defense, including Weiss Rhoda, Eric Stetton, Sam Zeskine, City of Homestead, City Manager Gretzis, Police Chief Al Roll, City Clerk Elizabeth Sewell.
Okay, very good. We're here on various motions to dismiss. You reserve 30 minutes. I'm going to give each side equal time, 15 minutes, and whoever the movement is, if they have any time left, will be the only party getting any rebuttal. All right, Counsel, you may proceed.
Thank you, Your Honor. We're going to try to get through these. I know we have several motions and you have 30
Well, I
minutes.
mean, I read the motions, I read the responses, I read the replies, so one of the things I wanted to ask you about, which is why I gave you NCAA versus the Associated Press,
Yes, Your Honor.
is in particular the language found at the bottom right, page 9 of what I gave you from Westlaw. It's the text at headnote 11 that specifically says the plain meaning of this is that the public records law can be enforced against any person who has custody of public records, whether that person is employed by the public agency creating or receive the records or not. And then it says it makes no difference that the records in question are in the hands of a private party. So somebody could sue John Doe on the street if they contend that they have public records, they're subject to inspection. And so I'm asking you that question as it relates to your motion to dismiss. And in fact, in NCAA, Gray Robinson was sued.
Right.
The NCAA, which is a private party, was sued. So I'm asking you that as it relates to your contention with respect to the private, what I'll call the private defendants.
Right.
How can I dismiss it in light of NCAA?
Your Honor, the only reason why the Weiss Rhoda or the lawyers are being sued here is because of the fact that they represented, as Your Honor, represented the City of Homestead. We were in possession of public records. There's no question. And
Well, the only reason Gray Robinson was sued is because they represented FSU in that litigation. in the
Understood.
NCAA.
And the point of the Public Records Act is it protects the documents. What's on the documents is what constitutes a public record. Who has possession of it? It's relevant only for purposes of you requested from the agency for which we represent. It's our obligation as agents for that agency, in this case the City of Homestead, to turn over all those documents to the city of Homestead. The only reason why we are sued, again, is basically because of our representation of the city of Homestead. In the statute, it specifically says, when you read the statute, it's that you're an agent only if you are acting on behalf of that public agency. So the case law that is being cited and so forth, these are cases, I understand the NCAA case.
Neither side really talked about that in their papers.
I know, it's interesting, but when you look at this actual language of the statute itself, Your Honor, that 119.12.
But are you asking me to not follow NCAA?
No, I'm asking you to follow the statute, Your Honor.
But NCAA says that you can sue a private party if they have public records. I mean, what I just cited to you says that in no uncertain terms.
Well, respectfully, Your Honor, I need to look exactly at the case, you know, if it pleases the court, if you can direct me to where the exact position that the point that you're looking at.
Okay, the text at head note 11, which is page 9 of the opinion, it says, the enforcement of the public records law is also relatively straightforward in a situation like this. Section 119.071A Florida statute states that every person, and they highlighted person, they added emphasis, who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so. The plain meaning of this statute is that the public records law can be enforced against any person who has custody of public records, whether that person is employed by the public agency creating or receiving the records or not. It makes no difference that the records in question are in the hands of a private party.
Again, I think it's because of the fact that we've been sued. You could sue, if you sue the city, you sue the city, you want all the public records that relate to whatever the subject matter is. It's incumbent upon the city to then go to its employees, its agents, whoever has possession of those documents.
You're right, it is.
And in our case, they come to us and they say, Weiss Sirota, our attorneys, you guys have a public record, you need to turn it over to us because we are the public agency. Weiss Sirota is not.
But is there anything that precludes somebody from saying, I'm not sure that the responding agency is going to do its good faith search, so I'm going to sue the other people directly?
Yes, there. When you look at Rule 1.610 Florida Rules of Civil Procedure, you're seeking injunctive relief against a particular entity. It says every injunction shall specifically specify the reasons for entry and shall be binding on parties to the action, their officers, agents, servants, employees, and attorneys, and on whose persons in active concert or participation with them who receive actual notice of the injunction.
She can't take you.
I'm sorry. She'll correct me. Shall be binding on the parties to the action, their officers, agents, servants, employees, and attorneys, and on those persons in active concert or in participation with them who receive actual notice.
I think what you're arguing is that it's redundant or superfluous.
That's exactly right, Your Honor. And I think that.
But I don't know that that means it's legally impermissible.
I think when we could be sued in our official capacity as attorneys for the city of Homestead. What Dr. McDonough is doing is he's suing us he's suing Weiss Sirota in their personal, the attorneys in their personal capacities. There is nothing that prohibits an entity from suing or a person from suing an individual in their official capacity. And again, in the case that is cited by the plaintiff, the WFTV Robbins case, they sued Peggy Robbins, but they sued her in her official capacity, and there they said she had the obligation in her official capacity to produce the documents. He didn't have to sue the city, he could have sued us in our official capacity, which, by the way, is a redundant claim. It's like suing the city. So you either sue the city, or you sue the agents in their official capacities. There's nothing that prohibits him from doing one or the other. So certainly he could sue us, he could sue Sam Zeska and Eric Stead in their official capacities as attorneys, and if that's the case, then I guess the court could enjoin them in their official capacities to produce certain documents. But you're talking about individual liability, and this case, and again, I have to read the case specifically about the individual obligations. But when you look at public records law, it has separate obligations for individuals versus agents. We are the agent for the city of Homestead. We are being sued really in our official capacity. The individual capacity claims are not supported by the law or by the statute itself. So that's a very important distinction that has to be made. And again, without having the opportunity to fully really tear through this case, Your Honor, that's what I could say as to that at this juncture. And I certainly, if the court wants to hear more argument on that, I would ask the court if I could have an opportunity to really look at this and analyze the case and address the court's concerns, because obviously it's a very important issue. I mean, they are suing our law firm and two of the individual lawyers in our law firm in their individual capacities. It takes much.
I'm really not sure what you mean by, if this was, let me finish.
Yes, I'm sorry.
Hear my question.
I'm
If this
sorry.
was for money, and we can address any claims for money.
Right.
Okay. But what they're saying is, if you're in possession of a public record, I want to inspect the property. I don't know what capacity, you know, I'm not, Gray Robinson in this case got sued, and they said if you're in possession of public records.
Come outside. Are you gonna come outside?
Wait, who is
I asked
this?
the gentleman who he is, he refuses to give me his name. It's an open quorum, I told him that's fine, but I want him.
He asked me if I'm here for this case.
Are you here for this case?
He asked an observer.
I'm sorry, I can't hear him.
He's here as an observer, he said. It's not right, just. All right. It doesn't matter to me what capacity, I don't think that's what the case law talks about. Case law says if you're in possession of a public record, I get to inspect and copy it for a reasonable fee. You know, so I'm not sure.
You get to inspect it from the agency, and again, it's our obligation to turn it.
Well, that's not what NCAA is.
Well, I have to, respectfully, I have to really look at this case, and if the court could let us have this indulgence once that comes out. Okay. My partner can speak as.
Your Honor, I just want to add to this. This was decided in 2009. The National Collegiate Association case.
You're not saying it's not good law, are you?
No, I'm not saying it's not good law, but since then, there's been a statute set forth that specifically details the obligations of contractors to government agencies.
The reason I'm so familiar with this is that I'm caught up in a very, very big public records. Breaking up counts for each request.
Correct.
As opposed to lumping them all together.
Correct.
So,
And that's another issue. And right, as most of these deal with the city, we may direct it to the city or to the city clerk or whatnot. And again, as I said, the official capacity claims, so those are truly redundant claims, because if you're in your official capacity, it's akin, there's plenty of cases on that issue that it's akin to an official capacity. I mean, it's a claim against the city itself. I also want to address, there is a claim against Mr. Zeskind in his individual capacity for violation of the Home Rule Charter of Miami-Dade County, Citizens Bill of Rights. And the three things that are being alleged against Mr. Zeskind all relate to acts that he took during litigation. It's barred by litigation privilege. Motion that he filed, statements that he made in hearings and during various different hearings in this matter, clearly that's precluded by Echeverria and the Levin Middlebrooks cases. Doesn't matter, the plaintiff is not seeking damages against Mr. Zeskind. It's litigation, it's absolute immunity against all proceedings. So therefore, that claim should be dismissed against Sam Zeskind in his individual capacity with prejudice. The individual capacity claims against Chief Roll, Elizabeth Sewell, Again, there's no allegations that, it's the same arguments. They're employees by the city. It's basically akin to a claim against the city. So the same arguments apply to Chief Roll and the city clerk. The city clerk is the records custodian for the city. They're suing her in her individual capacity, but they're also suing the city. I mean, what she has is what she's produced. So that claim is truly redundant. That claim should be dismissed. All the claims against this source should be dismissed. They also have untruthfulness claims against Chief Roll, City Manager George Gretzis for expressing an opinion, and City Clerk for emailing Mr. McDonough at 4:31 when she said she wasn't available at 4:30 on a day. We don't believe that the statements or the acts that are alleged against Chief Roll, the City Manager, and the City Clerk rise to the level of violation of the truth in government under the Hurwitz case, which I know the court is eminently familiar with that case. There's also various different ethics opinions that we told them. Yes, while they're not binding, we looked for research, what if there were any findings by the Ethics Commission as to a violation of the Bill of Rights. We found a couple where the Plantis versus Eddie Lim, there were two related to North Bay Village, and there they didn't find any violations of the truth in government provisions, where a commissioner falsely stated that a lawsuit was frivolous, and that falsely stated the mayor was under federal investigation, and then also the Switkiss opinion saying that an expression or feeling, a statement of opinion is not a statement of fact that can be the basis of an intentional falsehood. The only case that we found where there was an actual violation, it was the Carlos Hernandez case, and there he actually lied about a type of loan that he had. He said that he was, Mercy said he was only getting principal back, and then when he was testifying in federal trial, he said, no, I was getting interest on it too, and that was a big deal because that related to income that he was not disclosing as an official. So that was the only case only matter that we found, Your Honor, where they actually found a violation of this Bill of Rights, and obviously there wasn't a violation in the Herbert's case. The city claim, and I know I'm running up on some time here on the city's motion to dismiss. I think, Your Honor, that yes. Oh, right. Just to go back before the city claim, relating to the attorneys, to the extent that he's suing us for advice that we gave to our client, he obviously doesn't have standing to make those challenges. There's a couple claims in the complaint, or a couple of allegations saying that there was some type of some type of cause of action. I don't know whether he's asserting it or not, that based on allegedly
It seems
improper
like the counts
advice.
of the complaint, and I'll ask him when it's his turn, but are untruthfulness. I mean, that's what they're titled.
That's it, but it's a whole.
I understand there are allegations.
Right, that's true. And again, I mean, there's a lot of stray allegations, so to speak, and we have to kind of address them. I mean, he is a pro se plaintiff, so we don't know if those are claims that he's actually making or whatnot, so we kind of had to address them. But to make it simple, public records and the untruthfulness, again, we think the untruthfulness should be dismissed, the public records should be dismissed. The claims for monetary damages should be dismissed. He says that he's not seeking monetary damages, and then the next sentence he'll say that he's seeking a fine or refund. He's not entitled to that. There's also claims in there relating to the public records request that was litigated before Your Honor and already dealt with the appellate court. We think that is barred by collateral estoppel. He's saying he's not raising this issue, but yet there are allegations about why those exemptions are not good still in that complaint, and that should certainly, to the extent that he has a public records claim based on that public records request from October 2015, that should be dismissed. If I just can have court's indulgence on a couple more minutes.
Well, I do have another
I'm sorry.
case at 10:30.
Okay. I think our pleadings set forth pretty much everything. I think the three initial public records requests that were made that form the basis of this lawsuit, we produced all the documents already. One of the requests deals with delay. The request number one that was made in 2017, that the statutory amendment precludes him from any further relief. He's not entitled to costs, not entitled to fees. We produced those documents. That is clearly moot. The June 5th, 2016 request, which was request 2, and the November 2nd, 2016 request was request 3. He's alleged and stipulated in various different orders that we produced those documents. We produce those documents timely. He's saying that the fees are excessive.
Counsel, I have to let.
Okay.
I'm sorry.
Okay.
And next time, if you want to reserve more time, just reserve more time.
Yes, Your Honor.
All right.
Hey Charlotte County, this is Charlotte County COPWATCH, and I just wanted you to know that I am using this stuff under fair use. And also remember to like and subscribe this channel. Also too, keep in mind I do not make any money on YouTube. This is 5 hours work a day, you know, fighting for freedom. And you can donate with PayPal and Patreon. I just want you to think about this. If everybody gives to PayPal and Patreon, Patreon is every month. Actually, PayPal you can do every month. I have 12,000 subscribers. If everybody gives, I can quit my regular job and go full-time investigations on Charlotte County and possibly even more and beyond. So just keep that in mind. If everybody helps out, I can go full-time doing this. Thanks.